Hi guys, it's Kathy. I hope you're doing well. So, if you don't watch anything else today, go watch the first 3 minutes of my last stream. Called I don't know. I don't remember what it's called. In the matter of Kimberly Hurd, I think it was called. It's something like that. I don't know, but it's very, 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 very funny, and it'll start your day off great. It'll make you feel better. So go watch that. But today we're really cooking, guys. We're really cooking on this OJ trial. I'm so proud of us. We're doing so well. Um, we're gonna finish up January 26th today, and then it's a weekend, I think, and then we're gonna start on January 30th or 29th. I can't remember. Um, but what we're gonna do is we're gonna do all of January 26th today, and approximately 20 minutes of January 30th or 29th. I can't remember which it is. And then that'll be 1 hour. We're going to do 1 hour today. And then tomorrow we're going to finish the last part of that, and that'll be 1 hour. So, and the audio is going to be amazing. It just really is.
Respectful, as I've indicated. Uh, and I'm very concerned about his physical condition, and I hope that he'll get well soon. And I'm very concerned about it. I've discussed that with our client. But talk about sanctions. When have you ever seen a case, Judge, where, first of all, they get up and make an unfettered opening statement to our jury because we wanted to be professional? We didn't object to the very end. It became absolutely necessary. Because of events beyond our control, I couldn't start that day. We had to leave. The jurors got to go home that night. We came back the next day, and I got my chance to make the opening statement, in which the things that I said, I expect to prove. Things that I know from my client, I don't think that they can change that or talk about leveling the playing field. Because apparently they felt the job that I did made them nervous and upset the next day. We saw these histrionics. And so they now want you to carve out some new law. They have no cases that cite this, and you have a lot of discretion, Judge. They want to carve out some new thing to give them like another opening so they can get back up and talk. Well, then do I get a chance to respond to that? I mean, that doesn't make any sense. Everything that we did, we've done in good faith. We want to try this case as much as they did. In fact, you recall I've said for the last 10 days, let's stop all this posturing. Let's get this case on the way. The final thing I want to say is this, that it's rarely productive or good to malign citizens. You know, I'm a big fighter for jurors and for witnesses. And for Mr. Darden to stand here and say that Christian Reinhardt, was dumped by Faye Resnick is perhaps the greatest bit of hyperbole I've ever heard. That is so far from the truth. It strains credulity. It didn't happen. He put her out because she was using drugs. And after she used drugs so badly, in that 5 or 6 day period, he was the one who helped put her in a drug treatment place, Judge.
Mr. Cochran, as interesting as that conversation about that probably is and probably will be later,
Sure.
My interest is in the people's request for sanctions. They've asked me to tell the jury that I'm striking from your comments and for them to ignore your references to these various witnesses and items that they've discussed. They've asked me to admonish them that the mention of those was not appropriate because the prosecution was entitled to know of those witness statements or the identity of those witnesses before the opening statement was made. And they're asking for a 30-day continuance. So I'd like your observations on the various sanctions that the prosecution has requested.
Let me do that. Thank you, Your Honor. And the only reason I was thinking about the right card, I just felt you have to set the record straight sometime. There's a man, he's a doctor, Judge. He's out there having his slings and arrows. We can take it, but it's not fair to these other people to go through Christopher Darden's thing. I know he loves them too, but we can take it better. Judge, with regard to the 30 days, I think, again, Your Honor, it's almost like they're kidding about 30 days. Your Honor, they haven't even called their first witness. You know, you're very optimistic, and so am I generally. I'd like to think the defense is going to start within 2 months, probably more like 3 months. Judge, by that time, they'll have time to investigate everything. They've got the LAPD, they've got the DA's office, they've got everything. They got all this information they supposedly got on Marianne Gersh's, supposedly, which apparently isn't true, but they can have all the time they want to investigate. And as Mr. Douglas says, we're not trying to play any games, and to show that, they can have as much time as they want. I don't mind if we're going to call her as a witness, calling her at whatever time you set. I mean, we would play by the rules. I don't have any problem. We made a mistake with regard to her. With regard to the other witnesses, Judge, I don't think they can show there were any mistakes. I think that they knew about Carrie Mullis. They knew, I mean, they say to me that I say that he has this man suffers from rheumatoid arthritis. Those are the facts, and I'll be able to prove that. What do we strike based upon that? They don't like the truth, and they want to try to change it around. To talking about a level playing field. So as I listened to it, I didn't see, and I try to go through the list of witnesses. I mentioned Ron Fishman, and they know about Ron Fishman. We hadn't turned that report over. With Chris Reichart, they know about Chris Reichart, Judge, because they've interviewed him. We don't have a report, I don't think, from Christian Reichart. We don't have a report. And we don't have a report from Fishman, so we have nothing to turn over. They know about Lenore Walker, Judge. In fact, let me respond to that on Lenore Walker. With regard to Lenore Walker, we got a special order. She went to the jail over 2 weekends. She has not finished her examination, as I indicated to the jurors. We don't have a report from her, and we don't have one for either from Geraldine Butch Staley either, who's their associate, because they were due to go to the jail last weekend to finish their reports. They haven't finished them, or they finished the testing. So again, that's not anything. We tried to give them the CV. We've done what we could on that. With regard to Michelle Abduran, they know about Michelle Abduran. Joe Stellini, there's no report. So, Judge, the sanctions they're asking are far out of line with what should take place. I think we're in a similar position than what they were. What I'm trying to indicate to you is that we've not done anything intentionally. We would not do that. We're just trying to get what we know we can prove before this jury at the earliest possible time. It's the first time we had to do that. And so I would ask the court not to try to come back and then gut my opening statement by trying to pick out things that we said if it's the same situation. If we don't prove those things, the problem comes with that. Where does it say that because in an opening statement I make a statement believing that they have Marianne Gerges' testimony and they don't have it when they should have, because of the statement of itself, in that statement, if you look at it, has the DA's phone number. Marianne Gerges says she has the DA's phone number from Patty Fairbanks, who puts her on hold, and she tells about calling all these police departments. So and this is an investigator I have never met with, and I received that report within the last couple of days before the argument. So I think that if you look at it, what I think you should do is put us in the same position that you put the prosecution in when they were faced with the same situation in December. I mean, what's fair for them is fair for us. We wouldn't ask any more or any less. It doesn't go to my opening statement. Just much of what you have seen over the last couple of days, make no mistake about it, is to try to keep me from getting back up before that jury. There is an ultimate sanction today. Now, I believe that Bill Hodgman is sick, but everything that's happened, when Mr. Darden kept talking and saying the same thing 6 or 7 times, I thought he was filibustering, and obviously it was so I couldn't talk to this jury today. But ultimately, Judge, no matter what they do, I get to finish talking to this jury. That's not a sanction they can impose. I get to get back up there. They're not going to like that. And so that's what this is about. And so I'd ask you to be fair in that, and be fair like I thought you were imposing to them. If we slipped up, I'm telling you, it was not intentional. We would not do that. And if we slipped up, the same sanctions they got in December should pertain to us. And if that happens, it has nothing to do with the opening statement. I haven't misled anybody. If Christian Reichart...
Well, the problem is I can't really impose the same sanction at this point, because part of the sanction was I told them they could not use certain witnesses in their case in chief until they had completed their original witness list, and they could not mention it in opening statement, which, as far as Mr. Darden is concerned, I essentially took the heart out of his domestic violence argument, because he was not able to mention 3 or 4 other incidents that fill in certain time gaps. I assume that's the argument he's about to jump up and make.
Well, when you say take the heart out of it,
well, that's his argument.
Okay, well, yes.
I'm asking you to respond
yes,
to that.
well, I will. I think that, Your Honor, with regard
So
to
I can't give you, or I can't impose upon you the same sanction.
Well, you can get, I think the thrust of it, though, Judge, isn't it that they would have an opportunity to try and check these things out? I mean, I think for instance, Christian Reichardt, they already know about him. We don't have a report. So that's maybe a bad example. They know about him. They already have a report, and maybe that's a bad example. I mean, the only one that I can really fix on, because they know about Ron Fishman, is Marianne Gertjes. And I'm just saying to Your Honor that in 24 hours, they've done all this work, supposedly on the rest of the people, Judge, they knew about, and we don't have any reports on them. So I don't know where we go from there to saying, admonishing this jury regarding this. You admonished them, even after I didn't get a chance to talk to them for an whole evening. When they came in yesterday, you start off by saying, what counsel says is not evidence. And that's exactly what it is. It's not evidence. So, you know, we're going to have evidence. The case will ultimately be, why are they so afraid? The case will ultimately be decided. We want to uphold all the rules like everyone else. But why are they so worried about that, Judge? Ultimately, it's going to be the evidence that this case is decided upon. And that's all that I wanted us to get back to. The rest of these witnesses, and some again, is that they knew about them. We don't have any reports, with the exception of Marianne Gertjes, that I can see as I look at the list. And I think that the sanctions are way out of line with where we are. And having understood what your sanctions were back then, we have to deal with where we are at this point. With regard to Marianne Gertjes, this is a witness who gave a statement. I don't know her. I have a statement from her. The investigators talked to her. And that's how it came to me. I assume they had it, and I wasn't aware they didn't. And again, I apologize for that. But I don't think that's any reason that Mr. Simpson should have to suffer, where these jurors would have to be told, oh, gee, it's not evidence, but just disregard that. It's not evidence. And, you know, and Judge, if we do it based upon that, I could come back tomorrow and say to you, Judge, I want to look at the transcript for all the times Ms. Clark was argumentative that I didn't object because as an officer of this court and a gentleman, I didn't want to do that. That's like running back, doing something like that. I don't want to do that. I want to get this trial on. I want to finish my opening statement so they can call their first witnesses. And so what I'm going to ask you to do is to fashion something that's reasonable. You're wise, and in these situations, it calls for wise decisions. Well, we have done something in good faith, and I will conclude by saying this, Judge.
He just said he was going to conclude, right? Did we all just hear that? Please let him conclude. He's making my blood pressure go through the roof.
We certainly don't refer to ourselves as a dream team. Just a collection of lawyers who try and do the best we can for our client.
You don't have to tell me.
Others can refer, Mr. Darden can refer to us derisively or any way he wants to. But we're just trying to do our job. And in that, Judge, we're trying to represent our client to the best of our ability. I think you know, we would never intentionally mislead this court. We would not do that. I would not do that. I know that my reputation means far too much to me. And this case is not the last case of my career. And so we don't have the obsession that some seem to have about this case. We want to try this case. We think we're going to win this case. But we're not out here trying to win this case at all costs. We're trying to do it methodically and do the job that we're paid to do. And that's what we expect to do, ethically and morally, Your Honor. And all I ask you to do is to allow us, remember that part of the sanctions have already been the delays, the internal delays in my opening statement getting back to that jury. Allow me to get back to that jury without any real unnecessary delay. If the court felt that there was some problem with regard to Bill Hodgman, obviously we want to listen to that. I mean, that's something that I am sensitive to, and I've talked to Mr. Simpson about that, although he wants to proceed as fast as he can. I'm sensitive to that. But with regard to these other things, Judge, when you look at when it's reduced down, you know, things that I knew because my client told me, I don't have an obligation to that. And I hope I put the envelope and the other things in perspective. So I'd answer any other questions that Your Honor has for me at this point.
Well, you're objecting to the 30-day continuance that Mr. Darden has suggested.
Yes, Your Honor. I think that is far, far too long. What are we going to do for 30 days? Judge, we have a jury that's being sequestered. They've wasted another whole day today. I don't have to tell you that, but those are the facts.
All right. Thank you, counsel. All right, Ms. Clark, briefly, please. And let me ask you a couple of questions before we launch into this. Do you concede that Dr. Mullis was on the DNA list for the defense for the DNA?
Yes, I do. He was on the Kelly Fry list.
Yep.
His deletion in the trial list led us to believe that he was not going to be called at trial. And that is the problem that is posed, is that we were just beginning to prepare for the Kelly Fry, and then matters were transpiring at a rapid pace, we ceased preparation when it appeared that there was not going to be a Kelly Fry hearing. And that is the problem with him, but it's not nearly as egregious as the others, because we did have some notice of his existence for the defense. Let me indicate to the court that with respect to the 30 days, I believe it was the defense who indicated, and at the court's request prior to this, when they wanted time to investigate witnesses that they claimed they were given late notice of, although they got them far in advance of the last hour of opening statement, they asked for 6 weeks. They thought that was a reasonable time for investigation, as did the court. We're asking for less, even though we would be, under a parity of reasoning, entitled to the same amount of time for reasonable investigation. We are not obsessed with this case, Your Honor, but I wonder about the defense obsession, because their desperate tactics in throwing ethics out the window and behaving as they have is evidence of clearly the opposite of wanting the fairness and justice that we're entitled to in this case. There should be no mistake about it. This conduct should not be minimized this way. Mr. Cochran's very persuasive, very talented, very charismatic, but I'm sorry, Your Honor, in this case, he is wrong. He has done wrong. This is not the way to behave. This is not ethical conduct or behavior. And as I told the court, he glibly stands up to say, well, the people can address it all in closing argument. No. See, it's too late. Because by then, Your Honor, there have been months of time for whatever that jury has picked up that will never be addressed in trial, those witnesses that Mr. Cochran referred to that may never be called out of some kind of fear that he's thinking of, or witnesses that never appear at all, that after they've been represented in front of this jury, they will have that witness in the back of their mind, and that may be enough to persuade the one.
Yes, Anthony.
Any
Yes.
kind of relief that the court grants us at this point may still not be enough, because the damage may be indelible at this point, after him having mentioned all these people that he himself knows is in danger of not ultimately being called, because once they're investigated, it's determined they have records, they have felony records. These are people that really will not withstand the scrutiny. They know it. The defense knows it. And the willfulness of their tactics in delaying the discovery is shown by virtue of one simple fact. Early on in these proceedings, the defense floated up the name of Frank Chuchulo from Happy Camp. This was a man who came forward to say that he saw burglars, 2 white burglars, leaving the home of Nicole Brown. It was then discovered that he'd come forward to offer false information on other famous cases, and his credibility was exploded, as it deserved to be. And the defense realized that then they're going to have to hide their witnesses to prevent the exposure that would show them to be as incredible as they are. And that's what they've done in this case. So it's a very willful thing, and it's not a minor thing. This is a major form of misconduct that has occurred, and I don't want Mr. Cochran to minimize it this way. It is major. And if we look at, let me just contrast it for a moment, because I know what the court is going to say. Okay? Their statements were taken 4 or 5. I saw it.
I got a rule.
No. You might what? I'm sorry.
Never mind.
The counsel wants to compare the gravity of their misconduct to what
The judge just said, how am I going to rule?
what occurred with the people, and let me contrast the two. The statements turned over by the people were 2 and 3 weeks late. The statements turned over by the defense were 4, 5, and even 7 months late. We were sanctioned for that for just 2 or 3 weeks, and now they're fighting the sanction for 4, 5, and even 7 months for material witnesses. Obviously, witnesses they think are very important, because Mr. Cochran is outlining their testimony to the jury. And when you also look at it in this context, Your Honor, out of the tens of thousands of pages that we've turned over, dozens of videotapes, dozens of audio tapes, we were slow to turn over by that I mean 2 to 3 weeks, a few pages of discovery compared to what they did. We had 70 pages of discovery, Your Honor, until the last 2 or 3 days. Now they have doubled the amount of discovery in the last 2 or 3 days. What that shows this court is not only that the gravity is very severe, that the misconduct is very serious, but that it is not inadvertent and cannot be claimed to be. You don't overlook over half your case. And that's what they claim to be doing. I don't believe it. I don't believe it. Mr. Cochran is an excellent lawyer. He knows what he intends to use. He knew what he intended to tell this jury. His statement was typed and it was prepared. And he cannot come before this court and tell us that he didn't know about these witnesses before or was unaware of their statements. And the fact that that Mr. Jones can Mr. Douglas can stand up before this court and say, and try to excuse the misconduct by saying, well, this wasn't always the law. It makes it even more egregious, because what he's indicating is a desire to thwart the law, a desire based on his own belief about what he should be able to do as defense counsel. Unfortunately, the voters of this state have spoken.
Guess who doesn't have to work today?
They have said, we will not countenance any more of this hide-the-ball stuff, this shell game in the course of a criminal trial. We want it to be a real search for the truth. We want both sides to air their witnesses so that everybody can have full and complete investigation. And that is the problem with what defense counsel has done. They are trying to prevent us from doing our job. I want Mr. Cochran to get up and speak to this jury as long as he wants to. I don't want to stop him from talking. I want this opening statement to get going and to get completed. I want him to be able to put on every witness he desires. All I ask is the ability for the people to investigate these witnesses so that the jury gets the whole truth, so that we have an opportunity to show the jury who these people really are. And when these people are hidden from our investigators, we cannot let the jury does not get the true picture of who they really are. I would not be doing my job if defense counsel were permitted to trot a parade of witnesses up to that witness stand and I were to sit back and say, what's your name? What time is it today? Thank you very much. I should be fired for that. It's our job to search for the truth, and it's our job to show this jury the real credibility of who these people are, what these witnesses really is. And if this jury doesn't get to see that, they're deprived of the truth. And if they're deprived of the truth, the people of this state are deprived of justice, and I cannot allow that. That is not my job. My job as a representative of the people is to see that that does not happen, that any witness who is called is given thorough and complete examination, and what they are attempting to do here is prevent that. Mary Ann Gerches now claims that she called our office. This is not a woman whose credibility is unsullied. And if she did call the office, which counsel knows because counsel had the same problem, we've all gotten thousands of calls from every Tom, Dick, and Harry that wants to get involved in this case. If the person doesn't pursue it, sometimes they don't get reached again. But I think it's very interesting that they say that. What, are we supposed to now say that the lawyers can rely on the witnesses to give discovery? Is that what he's saying? She's supposed to give her discovery to us? I mean, somehow he's putting the obligation on her to come forward. No. The obligation is not on the witnesses to turn their statements in. The obligation is not on the DA's office to go begging for the defense witnesses to come and talk to us. The obligation is for the defense to give us what they've got, the same as it is for us to give them what we've got, and we have done so diligently at every bend and turn. We have not attempted to avoid it in any way. Now, I think that what the court should know is that Mr. Douglas's position vis-a-vis the law, vis-a-vis his requirements in terms of turning over discovery, taking reports, and reducing statements to writing is wrong, 100% wrong. It's so wrong that previous courts have found that conduct to be contemptuous. I cite the court to the case of In Re Serra, S-E-R-R-A.
I don't want to go to the moon. I just don't. I like oxygen.
484, Fed 2nd, 947. The court held that a defense attorney should be held in contempt for asking an expert to refrain from writing a report in order to avoid discovery. Also cite the court to Standeffer versus Superior Court, 18 Cal. 4th, 672. It cautioned again the attorney not to direct an expert to avoid writing a report in order to avoid discovery. Counsel has deliberately done an end run around the discovery laws, basically by trying to get their discovery from the mouth of their client. Here, Mr. Simpson, go call Ron Fishman, tell us what he'll say. And then they go and ask Mr. Simpson. I mean, that's a very clever game, but it certainly does not serve the ends of justice, and it does not comport with the spirit and the letter of the law under 1054. We love the fact that they have Henry Lee for an expert. But if he's such a great expert, he's so well renowned, and I understand he is, how could he not have written a report with respect to all of the work that counsel has told us he's performed in this case and will testify to here? No report? He's been on the case since day one. We're all aware of that. And to tell us now that he has no report to offer us, that Dr. Bowden has no report to offer us, that Sylvia Wolf has no report to offer us, this is unbelievable. You know, this conduct cannot be minimized, should not be minimized. We have been placed in it's a very unfair position that we are placed in. I think that the goal of a trial is for the truth to emerge, and it's not for a lawyer to hold in his head information that he or she may use to ambush the case with. And that's what we have here. It's a trial by ambush. That's the strategy. The people would request, number one, that the court admonish the jury with respect to counsel's misconduct, as I've indicated earlier. Number two, if the court is not inclined to strike the comments, the offensive comments by Mr. Cochran, and let me indicate about that envelope, he waved it in front of that jury and every single one of them saw it. And we all know that after the preliminary hearing with what occurred there, everybody knows about the envelope. Everyone on the jury said so. Mr. Cochran knew what he was doing.
I won't say anything other than I live in Pennsylvania.
That jury saw what he was doing, and that was a setup, as sure as I'm standing here, because he knew that he was going to surprise us with that, a surprise tactic, that we would object, and that the jury would then see the objection and maybe conclude that we were trying to hide evidence, when in fact what has happened is we've been hidden from. We don't know what's in the envelope. We haven't seen the reports. Counsel knows better than we do. They know what they're waving around. We don't even know. All we're asking is let us know. We want to know. We want to know what their witnesses have to say. We want to know what the evidence is. Is that asking so much? Under 1054, it's not asking anything that we're not entitled to. That's all we ask for. And under 1054, there are a certain number of sanctions that are allowed under the law, and Mr. Cochran is aware of that. And if the court is not inclined to strike the offensive comments, then the people would request that we be allowed to reopen to address those matters, but that's in conjunction with the admonition, and that after the conclusion of opening statement, that we be permitted a continuance in order to investigate all of these witnesses that were just recently thrown at us at the conclusion of Mr. Cochran's opening statement remarks yesterday. I think it's only the alternatives that I have posed to the court, I think, are the only way that the people can be made whole. We are not being hysterical here. We are simply asking for an opportunity to do our job. That's all we're asking.
How would I justify granting you a 30-day continuance if we all agree the people's case in chief is probably going to take between 2 and 3 months to present? Doesn't that give you adequate time to go out and prepare to rebut or to impeach these witnesses, these 12 or 14 witnesses who've just been disclosed?
While we're tied up in trial, we can't get involved in the investigation. That's the same game that's been played throughout this case. We're tied up in court with days and days of jury selection. We have to be out there too. We can't just send people out to do things for us without guidance.
Did she just accidentally hit the...
Yes.
Never mind.
I don't think that the people's case is going to take 2 or 3 months. Not even close.
Promise?
Yeah. I mean, I'd like to. But I really don't think it's going to take that long, Your Honor, seriously. I think that the people's case might well be wrapped up in 4 to 6 weeks.
All right. Do you have any other comment?
If the court would like, I think I have other case authority concerning the ability of the court to grant us the reopening of the statement.
Well, that's kind of an esoteric question. I think there are two other cases that I've been able to find in Lexis, but in other states.
I have a California case.
All right. Let me ask you another question. That's really an esoteric issue about reopening. What kind? What?
This case is right on point.
Well, as after an abuse of discovery, it's right on point. Reopening.
It's not to address abuse of discovery, it's to address something else, but it does indicate that it would have been reversible error to deny the ability to reopen the opening statement.
Ooh. Thing a trial court never wants to hear about. All right, Ms. Clark, let me ask you this though: what kind of admonition would be appropriate here?
I think I indicated earlier what
No,
my
I'm talking
request is.
specifics. Words.
Didn't I? Oh.
Just to pick out each one of these individuals' things and tell them disregard these comments? To say during the course of the opening statement by the defense counsel, this witness was listed, this person was mentioned, this person, disregard all that? Is that what you're asking me to do?
There would have to be,
And then say the reason for this is because we have rules of discovery, that is disclosure of witnesses, because they weren't disclosed and it was a surprise to the prosecution, they don't get to talk about it in their opening statement. And that's the reason for the delay. Is that what you're asking me to do?
I would like, may I have a moment, Your Honor? We have to,
Well, I mean,
We haven't
you're asking me to do things.
Right.
I want to know specifics. What are you asking me to do?
if the court would like me to actually frame the language of the admonition, I would be happy to do that. If the court could give us, well, it's kind of late already.
All right. Well, before you answer that question, let me ask you the question that's more pressing on my mind. is what is the condition of Mr. Hodgman this afternoon?
We don't have final word, and we will not have final word as to when he's going to be available to come back. We won't have that today.
Do we have any idea when he's going to be released? I saw Colleen Williams reporting a press conference down at the hospital.
Yeah, I believe the doctors held a press conference, but I have no idea.
Don't worry, she stands up in a second. There she goes.
What the people would request is that the jury be admonished as follows: that defense counsel has committed serious acts of misconduct, that they are to view very carefully the opening statements, they are not evidence, and that
It's
to
not
the
gonna
extent
say
that they
that.
fail to fulfill the promises made in an opening statement, any statements made should be disregarded because they do not constitute evidence.
Then
They should be-
that invites them to speculate that the whole thing is bad.
That what whole thing is...
Don't I have to be more specific than that? Because certainly not all of Mr. Cochran's opening statement is in dispute, or the propriety of it.
Well, Your Honor, we're going to have to take a break so I can frame then something more specific. I can't at this time, but they do need to be admonished concerning counsel's misconduct. They need to be admonished to disregard counsel's statement concerning the witnesses who will not appear out of fear. That was a totally inappropriate comment, very improper, and the jury very prejudicial. The jurors should be admonished to totally disregard that. There's no evidence to that effect. And then we should ask counsel at this time.
Mr. Cochran, I'm aware of your 1335 request, so.
We're
That's right.
entitled. We can litigate that later.
As soon as I receive a motion and application.
We also would request that the defense sit down with Mr. Cochran and review the balance of his opening statement to determine if there are any more witnesses he intends to mention that they've somehow magically forgotten to give us discovery of. We would also request that the court order them to reduce to writing all of these reports they carry around in their head with respect to the witnesses that are civilian as well as the experts who they intend to call. And
I'm mad for her.
we have no problem with the resumption of opening statement, provided it begins with the court's admonition to them.
Do you want Mr. Hodgman to be here?
I would definitely prefer that Mr. Hodgman be here, Your Honor. And I'm going to have to find out how long it's going to be. I don't know.
All right.
I feel like it's unfair of me to make a request to wait for his return if I don't know what that is, and so I'm going to have to ask leave of the court to get further information before I make any request along those lines, either way. I mean, if he doesn't come back for 2 weeks, is that fair? That's not fair to defense. And so I should really find out how long we're talking about before I ask for anything.
Mr. Cochran, you have a plaintive look on your face.
Yes, it's not like a plain will, but it seems like the press is being, like a plain will. The press is being told about Mr. Hodgman's condition through press conferences and things, and why don't they take a break, and then they can call and find out?
Because the press isn't being told when he's going to be released.
I think they should make an effort to try to find out.
Well, we will.
All right, well, why don't you take 5 minutes?
That's 'cause you're
My
a
court report tells me
superstar.
she's out of paper, so let's take
Superstar.
5 minutes. Why don't you make a phone call upstairs? And this is not a recess, so everybody stay in place.
I have asked to be beeped as soon as they find out. So
We don't turn on beepers in the courtroom, do we?
But my beeper isn't with me, so it's okay. My beeper's upstairs. They're going to call me. So I'm supposed to get a call the minute they find out.
All right, Ms. Robertson, what information did you receive from the ever-present Ms. Fairbanks? Mrs. Robertson, you'll need to speak up.
Due to the event with health meeting on his doctor's anticipated meeting sometime next week, that it be made, his wife is requesting that he have additional time off.
So he's going to remain in the hospital till next week?
Basically, that's what he's.
See, I had asked that as soon as we had knowledge that we'd be called, and they did. Thank you, guys. So that's all we know right now is that he'll be back sometime next week, at least released, but we don't know when he'll come back yet. That might be.
All right, in light of that,
Uh-huh.
She got a phone call in court. That's awesome. I hope you showed him the first 3 minutes of the other video.
Madam Reporter, have you changed your paper? All right. Ms. Clark.
First of all, Ms. Fairbanks asked me to inform you that the ever-present Ms. Fairbanks is here. She's gotten word from the press conference that they will not state exactly when Mr. Hodgman is going to be released. The doctors would not give a definite date. And as for his return, it's uncertain as to whether it will be the beginning part of next week or the end of next week.
All right, in light of Mr. Hodgman's absence, when will you be prepared to go forward in his absence? Can you be prepared tomorrow to go forward?
With opening statements or with evidence? Opening
The
statements.
whole enchilada. I assume Mr. Cochran he indicated he had one other segment of the case that he wanted to talk about. And I assume, although that'll be a rather large part, I assume it's not the whole day. So I would assume that he would conclude.
Judge, have you not met him yet? It's probably going to be the next 4 days.
This opening statement in the morning, and that we would proceed to witnesses in the afternoon, assuming we started at a normal hour.
I don't know if he just said tomorrow, but they don't have court tomorrow. We go from the 26th to the 29th and 30th.
Well, I understood. I mean, the court has not indicated any ruling so far on the people's request for a continuance to deal with the discovery that was just dumped on us over the past couple of days.
I'm asking you, when will you be able to do that? I'm mindful of Mr. Hodgman's absence. I'm mindful of the fact that he is a critical member of the prosecution team. I frankly will need time to go through my notes, prepare the record, because we were talking about, as I indicated, my recollection is we talked about 26 specific items of discovery and or witnesses, so this is not something I feel comfortable ruling from the bench upon.
Fozzie kept telling me to mute myself so no one could hear.
So I probably will not be prepared to rule upon your request and the for sanctions until probably late tomorrow is my problem. And I don't know that I want to drag the jury down to sit around and wait all day again. I don't know the answer to your question.
What we could do is let, there's a possibility that Mr. Hodgman will return on Monday. If, for the purpose of having him present for opening statement, we could do that on Monday. But then, what I thought we could do is sever the issues of the opening statement being completed and then
Well,
the request for continuance.
You've dumped a rather large number of things in my lap. It also is going to require me to go back through and read Mr. Cochran's opening statement again to go through the record to see what's mentioned and where. So this is not something I'm going to be able to accomplish between now and 5 o'clock.
No. And, Your Honor, this is from the defense. This is not from the people. But,
Your request, though.
well, it is our request.
All right.
Necessitated by. Anyway, why not start it, if we could have it go over to Monday for the purpose of completing opening statements. And at the conclusion of opening statements, would that give the court time to rule on the people's requests? And that way we would know where we stand.
All right. Let me just ask Mr. Cochran one question. All right, I'm contemplating going over to Monday. That'll give me time to review this, make my ruling, and we can find out definitively when Mr. Hodgman will be back. My inclination, though, is to direct the people to be ready to proceed if I rule that certain sanctions are appropriate, but that we're going to conclude the opening statements, that you be ready to proceed immediately, Mr. Cochran. And assuming that we proceed on Monday, that the prosecution also be ready to call witnesses Monday afternoon.
I'll be ready. I'm ready now, Your Honor.
I understand that. I'm ready, too.
No, that'll be fine. I'm ready, and make no mistake, it's the people's motion, not ours, and we don't agree with it. The one thing I'd like to say, Your Honor, however, with
Well, the
regard-
situation is, the creation of the situation, though, I think rests on this side of the table, as Mr. Douglas conceded that these statements should have been disclosed, so.
That's right. We've said that. We just said that it was inadvertent. The point is, Your Honor.
No, and I compliment Mr. Douglas for being upfront, saying we should have done this.
That's the kind of lawyer that he is, Your Honor, and we'd like to see that on the other side.
But it's the creation of the problem.
Your Honor, what I'd like to say is this, though. I would like to suggest to the court that I'd rather not have Marcia Clark drafting. I'd like for you to have that. I'd like to have that additional time. I'd rather not have her drafting anything that relates to us.
What I'm going to suggest is both sides submit by 10 o'clock tomorrow morning any admonition to the jury they feel is appropriate.
All right, thank you. I think that's fair.
All right.
Thank you.
All right,
That's
we'll
fair.
stand in
We'll be
recess.
ready on Monday?
9 a.m. Monday. Be prepared to go. Thank you, Counsel. 10 a.m.
So we're going to go 20 minutes into Monday morning, and then we're going to stop for the day.
All right, Counsel, you've each received a photocopy of the court's ruling regarding requests for discovery sanctions. My apologies to counsel for the court's failure to fax you a copy earlier than today. I experienced a complete breakdown of my fax program at home. I attempted to fax this to all parties yesterday and was apparently, obviously not able to do so. If the parties wish, I'll give them leave to review the ruling, and I would, court's ruling asks for input from both parties regarding opening statements and the jury instruction.
Yes, I read it. I read the procedure.
All right. Ms. Clark?
We'd like the opportunity to review it more carefully, Your Honor. There are a number of items that I'd like to take up with the court and have an opportunity to confer with co-counsel concerning the court's ruling.
All right. How much time do you think you need?
I would like at least until 1:30 to address these matters.
Well, Ms. Clark, let me tell you what I think the two issues are that we need to resolve this morning. You've seen the court's ruling and the court's proposed jury instruction to the jury to disregard opening statement comments regarding the witnesses that are listed on page 4. This is significantly different than the instruction that you requested. You requested an instruction directing the jury to disregard the comments of counsel. I think that is overbroad. And I think the only remedy is to mention or to ask the jury to disregard defense
I love that she did that. Just disregard all their comments.
counsel's reference to these particular witnesses, or if there are any others you feel that have been mentioned in the record that whose mention was inappropriate.
I don't appreciate that for you.
All right. Do you agree with the list that the court has taken from the record?
That's the only, with respect to this area, I was reviewing the transcript last night, and I thought that there were more references to other witnesses.
Well, that's why I asked for a draft. I asked both sides for a proposed instruction because I was seeking particularity with regards to the court's instruction to the jury. This is the list that I have here on page 4 as a result of my going through the record line by line, noting where these persons had been mentioned and then comparing with the witness lists that had previously been disclosed.
I'd like to hear the arguments.
Oh, certainly, Mr. Kirk. Sure.
There are certain notable witnesses who are not mentioned that we specifically delineated to the court when we were last in session. With expert witnesses promised by the defense, although not by name, who have never even been disclosed by name to the prosecution, such as an expert in tire tracks, an expert in shoe prints, an expert on finger cuts, an expert on rheumatoid arthritis. None of these have even been named to us. And then again, the statements made by counsel concerning alleged conclusions drawn by experts Dr. Bodden and Dr. Lee. We have no reports. We have no idea what counsel intends to present in the way of their testimony, having had no discovery. So there are many more that I would add to this list, and that the court is aware were not disclosed to the prosecution in any way, shape, or form.
All right. Well, you'll notice that the court's order includes those specific persons, and I make reference to the transcript where certain expert testimony is mentioned, and it includes the ones that you've just listed now. And I think that the requirement at this point is that they be disclosed, since obviously there has been indicated an intention to call those persons as witnesses.
Where does the court indicate to the jury that those experts have been?
No, we're not there yet. Flip back to page 2, where we start with a section on expert witnesses. All right, first full paragraph after the quotation from the code section. There's an order from the court directing disclosure of these persons, reports, etc., and in addition, other experts mentioned by defense counsel at these particular places in the transcript, which include the ones that you've just mentioned.
Is this part of what the court proposes to say to the jury?
No, because I think what I need to do is first determine who these people are, because they may be persons already disclosed to you. But I'm concerned, my concern here is also the reports.
Then we have another
If the people were not mentioned by name to the jury in opening statement, those witnesses, the people are not aware of who these experts might be, even
But
by
Ms.
name.
Clark, if you read the first sentence, it says the defense is therefore ordered to immediately disclose, blah, 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 and the identities of these persons.
I'm aware of that, Your Honor, and all
All
I'm
right,
saying
so I
is
assume that that's going to happen today. Now, after you've had the opportunity to find out who those people are, then you can make your judgment as to whether or not they should be included in the court's instruction to the jury.
then I'm unable at this time to indicate to the court what the people's position is with respect to this ruling, because there's information we still don't have.
Well, it's a ruling. After you've had the opportunity to look that over, I'm going to proceed today. My inclination is to instruct the jury, as I've indicated today, and to move on with the case. And if it comes to light that there's something else, I can always re-instruct the jury as to other particulars.
But there's already an indication there are other witnesses that have not been disclosed to us by virtue of counsel's opening statement concerning those experts.
We don't know that yet. I have the suspicion that the tire track person is probably Dr. Lee.
Well, a suspicion is certainly nothing that we can call
So then
discovery.
here's suspicion, it's Dr. Henry.
Well, thank you very much. I finally hear this today, this morning. That people are entitled to discovery, Your Honor, not an assumption and not a suspicion.
We've given Dr.
We haven't been
Hold on.
told anything,
Hold
we
on.
haven't seen a report.
All right, I agree. And Ms. Clark, that's why I've ordered its immediate disclosure, which means today.
And I appreciate you, Your Honor. I really do. But I'm asking for the court to inform the jury that we were not informed of any of that either. That should have been disclosed to us as well, not just these witnesses, but the experts and what they were going to testify to. Why do we find out only in opening statement that Mr. Cochran intends to call these expert witnesses to testify to various things of which we had no knowledge? The code requires them to do so. Those experts that he mentioned in his opening statement, in which we had no discovery, and only now, based on the court's stated suspicion, do we hear that that's who is going to testify to what he represented to the jury for the first time ever when we heard it. That's a blatant violation as well. We were entitled to know about that.
Hold on.
just as
Mr. Cochran, you'll have the opportunity to respond.
we were entitled to know about those witnesses, just as we were entitled to know about the witnesses listed by the court in this order. That's why I'm asking for the court to include them in the order. Why would they be any different?
All right, let me ask you another question. What is your position on your request to reopen at this time?
The people strenuously urge the court to allow us to reopen. I will cite to the court the civil case that I brought down to court the other day. Unless the court already has it through Lexis, but it does authorize the reopening and opening statement. I'd like for the court to see that. And we would like to reopen. The court has requested a proffer as to what we would address in the opening
Yes.
statement. And we will, until Mr. Cochran completes the opening statement, we're not going to know the entirety of it, because although it's been represented to us, we have full and complete discovery, we obviously do not. And I don't know what other surprises are going to be forthcoming from Mr. Cochran, so I can't give a complete proffer as to what we would state at this time.
Well, as to the individuals who are listed in the court's proposed instruction, as to those listed individuals, what is your proffer?
Well, we don't have a statement yet from Michelle. We don't have a statement from Mark Partridge. We don't have a statement from Howard Weitzman. We don't have a statement from Skip Taft. We don't have a statement from Christian Reichardt. We still don't have discovery of that. And in order to know exactly what I'm going to say in response, I need to have a statement.
My recollection is that is a list of people whose statements were belatedly given to you and/or... Yes, those statements were given to you, albeit at the close of business after the first day of opening statements by the defense.
No, Your Honor, we have never received a statement for Michelle. Mark Partridge, I believe there's a one-paragraph representation that he spoke to defense counsel, but no particulars as to what he said. Howard Weitzman, we had no statement. Skip Taft, no statement. Christian Reichardt, no statement. There's only one witness here for which we really have a statement, that's Marianne Gerges. And we are putting together our proffer as to her at this time. I believe that Mr. Darden will be bringing it down with him.
Well, hold on just a minute, Mr. Cochran. I just wanted to settle where we are at this point. All right, Mr. Cochran.
Yes, Your Honor.
Good morning, sir.
Good morning, Your Honor. We
Here comes some
sketched
lies.
this order this morning, a proposed order, and we've had a chance to review it. I'd like to, first of all, turn our attention to the list of witnesses that the court proposes to tell the jury about in the jury instructions, which I think is the heart of Your Honor's proposed order, obviously. With regard to Marianne Gerches, Mr. Douglas has indicated that, and our position is and will always be and absolutely is, that when I read the name Marianne Gerches, I believe that statement had been turned over. It, in fact, hadn't, and we indicated that. With regard to Michelle Abduram, there is no statement. With regard to Mark Partridge, the prosecution, Your Honor, had, in fact, been given a portion of his statement. In fact, in a letter that he wrote after a memo where he's a lawyer, as the court is aware, when he returned back to Chicago, if I recall, and I'll try to find this, Mr. Partridge wrote a letter detailing his observations of Mr. Simpson and sent a copy to the prosecution and to the defense. Mr. Douglas turned over another 2 pages, I think, afterwards. They'd already been notified of Mr. Partridge and had an earlier statement, and I believe they also had his lengthy memo about what had taken place. With regard to Howard Weitzman, Skip Taft, there are no statements. These are both lawyers, and we try to explain that to the court. There are no statements. It's no subterfuge. If the court is aware of the relationship we would have with Skip Taft, a business lawyer that we talk to on a daily basis, there's no report.
Well, the problem, Mr. Cochran, is that neither of these persons appear on your witness list.
But that, and I appreciate that, but I'm saying there is no report regarding those two. With regard to Christian Reichard,
But the fact that they were not placed on the witness list, there's no notification to the other side that they're going to be witnesses. That's the problem.
all right, and I understand that I've indicated to the court that's through inadvertence, and I understand Your Honor's sanction on that. With regard to Christian Reichard, they have interviewed Christian Reichard at length. He's on the list. Interviewed him at length with Dominic Rubalcava, the lawyer. There's a transcript of that effect, I believe. And we have no statement. We have no report from Christian Reichard. So I guess what I'm asking the court with regard to Reichard, I don't understand where the prejudice is. We have no report. They know about him. He's Faye Resnick's former fiance. You heard what Mr. Darden said. You know, and it's
Thank
very
you,
interesting, Your Honor,
Gary.
how Mr. Darden could immediately make some statement maligning Christian Reichard when he knows everything about him. Or for instance, with regard to Marianne Gerches, when they heard the name, it seems as though they'd already known about her. And the court will recall that with regard to Marianne Gerches, this is not to obviate whatever you feel is proper. I'm prepared to go forward and argue. Marianne Gerches had tried to contact the district attorney's office. The court should read that statement. She not only talked to Patty Fairbanks in the DA's office, she puts in the statement, if I recall, the phone number in the district attorney's office that she called.
Mr. Cochran, though, that's dancing around the issue.
All right.
The issue is, was this person named as a witness by the defense?
No,
and
she
were
was
the
not.
statements in your possession turned over prior to trial? The answer to that question
She
is
was
no.
named. She was named, I believe, but the statement was not turned over, as I've indicated to the court. But
That's
I wanted
a violation of the discovery rule.
Okay, and I appreciate that, Your Honor, but I thought the court should have all the facts. And I think what it does, it goes to the state of mind, our state of mind. Your Honor, and I'd just like to say this again. No way in the world, why in the world would we want to withhold witnesses from them that you could possibly preclude down the road? I'm not going to do anything to damage Mr. Simpson. And the effort of this is a massive volume of work, is not an excuse. We want to get this case underway. We're not going to do anything to harm that. We want to try the case. We're the ones who've not waived time and want to get it forward. We understand we have to all abide by the rules, and we accept that. The other thing I think that the court should listen to is that this violation of, in the jury instruction, proposed jury instruction, the court proposes this was violation of the law and the cause of the 2-day delay. Well, that's not completely correct, because as you indicate later, the part of the cause of the delay was the illness of D.A. William Hodgman. So I think the court needs to modify that in some way so it more accurately reflects the facts. If that was the only cause, we perhaps could have argued on Friday or whatever. So I think that I would ask the court to consider that. With regard to the experts, we will comply wherever possible, Your Honor. We do not have reports yet, because much of the reason we don't have reports, Your Honor, is because our experts have not been able to actually examine the evidence. We're making a motion to that effect. To be able to examine this evidence in their lab, they can then make the report. We know generally from their observations what they're going to say. And for counsel to say that they didn't know about Drs. Batten and Drs. Lee, and Dr. Lee and Dr. Wolf were out here the week of June 12th, Your Honor. The court is aware. The other thing is, as the court correctly points out, in this reopening of the opening statement, it is illogical at best, and I think it's going to be confusing At worst, allow them to reopen to talk about Marianne Gertjes. From that standpoint, I think that if you admonish the jury to disregard it, then they get up and then talk about her. That doesn't make any sense, Your Honor. Then do I get a chance to respond to what they have to say? Your Honor, what's happened in this courtroom is they have continually maligned witnesses, and that is an intimidating effect, and that is wrong. And so while we're talking about the defense, let's talk about them. Over this weekend, every one of these witnesses who were maligned by Mr. Darden now have lawyers. Marianne Gertjes, Christian Reichardt, Ron Fishman, and Rosa Lopez.
Your Honor, I object to this. None of this
Hold
is
on, Ms. Clark.
responsive.
Ms. Clark, please.
None of this is responsive to the court's
I'm
question.
going to instruct counsel not to interrupt other counsel's statement. This court is more than patient. I allow each side to completely say what it is they want to say. I'm not going to tolerate any more interruptions by counsel from either side. That's a warning to all counsel. Next violation will be dealt with by sanctions,
Thank you.
including contempt.
May I proceed?
Please.
Thank you. Your Honor, what I was trying to say was that I think that it's totally improper to do those things under the, because it has an effect on these witnesses, and I think it's totally unfair. Now, what the court's going to see is in the coming weeks, these lawyers will all be addressing.
All right, guys, we're going to go for another, 2 minutes. Hopefully, let me just look. We're going to go till there. Until he stops talking, which means forever. And then this is automatically going to go and to raid Courtroom Cat. Courtroom Cat doesn't start for another, it'll be another 25 minutes after we get over there. It'll start. So we can hang out and chat for a bit before it starts.
This issue, and it has a pronounced effect when a district attorney stands up and says that and does that in open court. And I think that is germane what we're talking about and to procedures, Your Honor. So I would just like an opportunity, if the court would allow us, to
Do you see what you created, Fozzie? Do you see what you created? I just streamed for what? 3.5 hours? And you are both telling me I have to do more. Nan, do you have a belt? Do you have a belt, Nan? I think some people need to learn some lessons. I do have some videos I'm putting out today. Or, I have some videos, but I don't know if I'm putting them all out today. I might just put one out today, one out tomorrow, one out. I don't know. I'm not really good at holding videos, though, so I probably will get them, all 3 of them. Maybe 4 out today. Lori, I got one for you. It's only 3 minutes, though. Should I put out a 3-minute video? Sure, why not?
respond to the people's request for this reopening. As I said, I think that's totally be an improper
Well,
procedure.
Mr. Carpin, what I anticipate doing is after I hear the prosecution's proffer as to what it is they would go into and how it is that they would approach it, then I'll allow you to respond to that to see if it's appropriate.
Thank you, Your Honor, because I think that what we've seen so far, again, is trial in the media. What we saw in court here, to have a witness who's never been before this court, I presume branded as a certified pathological liar, Your Honor, that's outrageous. And if not, would not be done except under the aegis of some kind of qualified immunity here in court. And I think that's unfair to that witness, and obviously it had a great effect upon her. And what kind of message does that send out to other witnesses, Your Honor? Furthermore, all the things that were introduced, Your Honor, the things that were introduced would probably not even be admissible from a standpoint of attacking this lady's credibility. She has some civil lawsuits. How is that relevant as to whether or not on June 12th, 1994, at about 10:45 in the evening, she saw 4 men running from the vicinity of 875 South Bundy? That's going to be really the issue, Your Honor, isn't it?
Absolutely.
That's the issue, and it seems to me that the other things that happened should not be allowed to happen again, because I'm just saying to the court that this is having a pronounced effect, and I know that because I'm being contacted by these people.
All right. Thank you, Mr. Carpenter.
Thank you, Your Honor. I should say one other thing. At the bottom of page 1, I think it was clear as we'd indicated to the court. The other witnesses that were turned over, because the court had ordered Mr. Douglas to make that determination, and we should make it clear that he did exactly as you had asked, and make it clear also that this has not been his responsibility prior to January 2nd of
Well, I
1995.
think the record speaks for itself.
All right, I
Mr.
want-
Douglas did indicate that was his responsibility as of the beginning of the year.
Yes, and he either took it over, and of that list, of the total list that we've heard so much about, Your Honor, and we dispute Mark Partridge because we think they did know him and had a statement from him, the only two people that basically mentioned in the opening statement were Marianne Gertjes and Michelle Abdram. And apparently there is no report that we have on Michelle. And I will make sure. And the other thing that also comes to mind, Mr. Douglas reminds me, is the court will recall that in one of his diatribes, Mr. Darden stood up and said, if Ron Fishman tells the truth, he'll say that O.J. Simpson made a statement about getting somebody. Now, Your Honor, we've never seen any report like that. We've never seen any such statement. And so when he makes those kind of statements, or when immediately he knows about Marianne Gertjes, in another statement he says, if you recall, if Mr. Cochran had asked me, I would have told him about this witness or these witnesses. How does he know those things, Your Honor, immediately if he didn't know about these witnesses? I think the court, in being even-handed, which you are, would want to inquire about that.
Well, I've already sanctioned the prosecution severely for their transgressions in the discovery process, and this sanction proceeding process, I suspect, will continue throughout the trial.
I certainly hope not after today, Your Honor. It will not be proceeding. I hope it won't be necessary. But I understand that. But I'm saying, how would he then be in a position to give me advice about witnesses if he'd known, or to know, have a statement from Ron Fishman if he didn't know about Ron Fishman? I don't understand that, and I don't think that makes sense. So I would ask the court to inquire about that. To conclude my point, though, of the witnesses that you'd ask Mr. Douglas to proffer before the court, we did that. As Mr. Douglas has indicated, many of these witnesses were out of an abundance of precaution, will probably never be called. But secondly, they have a right to know about it, and we've done that. But almost none of those witnesses were mentioned in the opening statement, with the exception of Gertjes and Michelle Abduran, as I said, referring to the list at the bottom of page 1.
Well, you did mention Gertjes, Abduran, Partridge, Weitzman, Taft, and Reichart in your opening comments.
Right. I was referring to the list at the bottom of page 1, and I did, in fact, mention the others. And as I said, there are no reports, but I did, in fact, mention them. But I think, again, Your Honor, in the spirit of the law, the prosecution, Your Honor, knows about Howard Weitzman and Skip Taft because they were down there with Mr. Simpson at the time he gave his statement. Now, we don't have a statement, and it was an oversight, and they should have been put on the list. These are two lawyers. Now, you know, I mean, I don't think the court's going to shoot me over that. I mean, I think that he may want to.
Don't
but
tempt me, Mr.
I don't think you're going to shoot me over that. And Kristen Reichart, Your Honor, they know about. They've interviewed him. They know that's Faye Resnick's boyfriend. And I think that, as I said, with Mark Partridge, they had a statement on him. So I think the court has listened to us. I'd like an opportunity to respond specifically when they're ready. But I'd like to proceed, Your Honor. Let me just close by saying the court can give these proposed sanctions, and you've done that for the prosecution. I mean, I think it should be clear they were sanctioned, and you did that, and now you impose sanction upon us. We will proceed with those. I think that you should make some adjustment in that.
Which one?
In the order regarding the delay. I think it's not fair to say it was all the defense. But we're then ready to proceed, Your Honor, and I would like to be able to proceed this morning. Keep in mind, if you want to talk about sanctions, how unfair it is to Mr. O.J. Simpson. But number one, through no fault of his, I couldn't respond immediately when the prosecutors had finished on Tuesday. The court declared a recess. On Wednesday, I was able to start responding. Then we had all these objections from the prosecution. Then Mr. Hodgman gets sick. Then Thursday and Friday, we've been off. The court says, be ready at 9 o'clock. We come in, we get the order.
John Love, this is going to take a year to get through. So I have no idea. I have no idea what we're going to do next. It probably hasn't come out yet. Although I would really love, what I would really love the most is to get the Night Stalker, Richard Ramirez. But I don't know if I can get it. If I do, it's going to cost me a bit. It's going to cost me a bunch of money.
Order about 8:30. We're ready. Ready again. I've been ready for about now 10 days to give this opening statement. Now the prosecutors...
And I make about 13 cents for each of these videos. So I don't know if I want to spend all that money.
says, gee, Judge, we need now till 1:30. I mean, at some time, I should be allowed to complete the opening statement, Judge. And I think that that also is taking the form of a sanction. And I think it's a sanction that's not only upon the defense, but directly upon Mr. Simpson. I'd ask the court to allow us to go forward this morning.
All right. Thank you, Mr. Clark.
Thank you, Your Honor.
Ms. Clark.
Okay, we're gonna finish and the last hour of this tomorrow. That's what we're gonna do. I know, Lori. I am. No, I did not have to pay for this series. That's why I post the link where I got the video from in every single video, so that you can see the place that I got it from on YouTube. Give them props. So again, for all of you who missed it, Soda Poppin' lost today. Yesterday. Soda Poppin' lost. I know you don't understand what that means, but there's this little tiny little game called World of Warcraft. And there's this guild that's bigger than the rest in World of Warcraft called Only Fangs. And Soda Poppin', #1 feral druid in World of Warcraft, hands down. He's been playing for like 25 years. And he gave the guild to someone else. A jerk. Yeah, I said it. I said what I said. Who does not know how to run a guild. The biggest guild in World of Warcraft. And then to level his character, he leveled his character, and the guy didn't want to give the guild back. So they were like, okay, we will fight for it. PvP. Player versus player. They fought today. And what happened was Soda Poppin' didn't fight as a feral druid. Soda Poppin' fought as a warrior, a class he never plays. And he had his crit real low. The whole thing was who was going to crit the most. Soda Poppin' lost, guys. Guys, this is really bad. It just hurt my heart. Now we got this Taylor 1 who's a jerk running the biggest guild. And we love Soda Poppin'. And I'm going to go cry for a bit. Okay? I'm going to go cry because this happened today. It hurts my heart that this happened to World of Warcraft. To all of us. We're all victims of this. We are all victims. And we should write a letter or something to Taylor 1 and tell him to give him the guild back. Fine. Thank you for coming out today. Courtroom Cat starts in 19 minutes, I think. 19 minutes. I know, Nan, I know. I'll see you all there. I'm going to step away for 19 minutes. I'm going to move myself from this room up to my bedroom where I belong at this time of the day, where I'm supposed to be sleeping. All right, guys. Thanks for coming out. Thank you so much. I will see you soon. Sooner than you think. Bye.